Hey, Ken, how are you today? Are you muted? There you go. Well, welcome everybody to this presentation on LLCs with Ken Crotty. Ken is a licensed attorney and the father of 3 daughters, so Ken fears nothing. Today's presentation will not be nearly as boring as normal because Ken is not as boring as the other presenter, Alan. If you have any questions during the presentation, call someone who might know the answer or put your question in the question box. Okay? Also, at the end of the presentation, Alan will come on and he will talk more about EstateView software, and I will go to sleep because I'm so sick of hearing about it. But I don't want to get sideways with him. All right, without further ado, here we go. Okay, let me turn my volume up. Ken, is your volume working? Josh? I don't hear him. Is his volume working? I'm not hearing him. All right, so I'll get started while Josh saves the day. Today's talk is on using LLCs and limited partnerships. Most of our attendees are CPAs and attorneys. A lot of our attendees are regular old people. So we'll be covering this at both levels. If you came in through the CPA Academy, you'll get 1 CPE credit if you answer our silly polling questions. If you came in through our website, you can get legal credit by just letting us know that you're a Florida lawyer and that you watched this and that you did not fall asleep during any of it. If you have a question, just go to the Upside Down Pyramid, sing the King Tut song by Steve Martin, and ask your question, and we'll pretend to see it only if we know the answer. This will be posted to our YouTube channel later tonight, where people can watch it, whether they want to watch it or not. Please remember not to read our Thursday report. We're running way behind. The last one we did was June 29th, so we definitely owe our readers a Thursday report pretty quickly here. Next week, I'll be covering using installment sales for tax planning purposes. Then the following week, we'll be on with Gentry Burns and Katie Pimble, very, very good trust advisors who have opened their own trust company, the first woman-owned trust company in Florida that anyone's aware of. If you want a free use of EstateView software, tell EstateView that you are test@test.com, use the secret password test. If you go to estateview.link, you'll see it, and I'll be demonstrating it after the hour. You won't get continuing education credit or any knowledge at all from watching my presentation. You might want to anyway. Thank heaven we just heard from Ken. By the way, everyone attending this is getting a free PDF of our 8 steps to a proper Florida trust and estate plan. And let me just go to the first polling question to get 1 out of the way, because we'll have 4, and I think you have to answer at least 3. What key aspects should you consider when utilizing limited liability companies and limited partnerships for tax, estate planning, and creditor protection purposes? A, protecting family wealth across generations and from sea to shining sea. B, reducing exposure to personal creditors. C, ensuring proper documentation of the entity. And D, utilizing charging order protection. And of course, the best answer is E, is for elephant. Actually, we have an elephant here in the studio today. All of the above. So if you could just click any of those letters, we'll give you full credit for the first polling question. Or if you're a pole vaulter, let us know and we'll give you credit for 2 of the questions. Or if you're from Poland and you're a pole vaulter, we'll give you credit for 3 of the polling questions. Matt, are we ready? We're ready. Okay. So, by the way, at in about 40 minutes, Ernie Dover is going to join us from Nevis, live from Nevis or Nevis, depending upon how you pronounce it, to talk about offshore LLCs. So, Ken, where would you like to start? And I'm looking forward to listening.
Thanks, Alan. And Josh, you're giving me control of the slides, right? There we go. All right. Hold on one second. I apologize here. Josh, I might need another moment of help here. I apologize for the technical difficulty.
Click on display settings.
Display settings, yes.
And then click on the first one.
Swap. There we go.
There we go.
All right. Thanks very much, Alan.
Sure.
So what we have here in the beginning, I'm not going to waste the time on it because I just spent time before, is briefly the introduction about the way to qualify for CPA credit for the CPAacademy.org. You can go through these steps to help make sure you'll get credit going forward. Again, just real quick, how to ask a question. If you click on the arrow you see there, you will be able to ask a question. So we have an upcoming schedule, free webinars available also on the YouTube library channel. It's encouraging, like Alan said, to possibly learn something on those items. And then again, with respect to the Thursday report. So moving forward to a couple of polling questions we're going to slide by. We talked about Ernie Dover. We talked about the Nevis LLCs. So let's start with our basics of using LLCs. The goals. One of the items when we lay out for clients when they walk in is we need to know what they have. We need to talk to them about the possibility of creditor protection. Obviously, that's where your LLCs and your LLPs come into play. Talk to them about estate tax protection. That's also where, again, LLCs and LLPs come into play because you can take discounts for lack of control, lack of marketability, and it can help to reduce the size of the gross estate of the client for the purposes of any potential federal estate tax exposure that they might have. In addition, you can make sure that the assets are in structures that are protected from subsequent spouses and lifetime children descendants, and also help to address any special concerns that the clients might have. Kind of our process.
They just have control of mine. No, yes.
This is the process of going through the process with the client.
Well, you see here. And also treasure. Somebody said.
And we're getting some back feedback. And the team of advisors is important as well. So when we turn to the limited liability entities, here are the various entities that we could be looking at. One was a general partnership. That's a default entity. It's not very popular anymore, and the main reason for that is that the pass-through taxation is available. That's fine. That's not a bad issue. But you have personal assets being at risk because it's a general partnership. There's no limited liability protection for anybody involved. Now, a combination besides that is a limited partnership. Now, with respect to a limited partnership, the limited partnership itself is a pass-through entity. The limited partners are generally protected from the risk of torsion, of having liability. But the general partners do have some exposure still. The LLPs that you see are professional service business entities. Those are entities generally, which could be a combination of attorneys, combination of CPAs, et cetera. Generally with the LLPs, there's some protection in that you may have liabilities for the contracts of the entity as a partner, but you're not going to have liability for any tortious activity of another partner. LLCs offer great more flexibility. You have the ability to pick how you're going to be taxed. You can be taxed as a disregarded entity, which is a sole proprietor. Single member LLC, which is a pass-through entity. You can be taxed as a partnership if you have 2 or more entities, which again would be a pass-through entity. You can be taxed as a corporation or as an S corporation if you make the necessary election. So you have the flexibility there. The great thing about LLCs is that the members and the managers should have limited liability, assuming that all the corporate formalities are followed. With a corporation, one of the things with corporations is, other than possibly Nevada corporations, corporations generally do not have charging order protection or offer really any protection at all with respect to the shareholders other than from the business debts. You're going to have taxation, double taxation for corporates. If it's a C corporation, if it is an S corporation, it is going to be treated as a pass-through taxable entity. So real quick, one thing just to mention, as Alan pointed out, we had E for elephant. It is National Elephant Day. So we're going to go ahead and continue with the bad humor. Two quick jokes. Why don't elephants like using computers? And the reason is because they're afraid of the mouses. And what do you call an elephant that doesn't really matter? And the answer for this is irrelevant. So we're going to continue with the bad humor. Alan wasn't a party to the past bad humor that I had when he was in London. I still think my best joke of that day was, what do you call London without electricity? And the answer there is Lundoff. So no guarantee that anything's going to get better, but we'll try. All right, so LLCs and limited partnerships. Again, a brief overview. LLCs, you're going to have members, and you're going to typically have managers. The LLC structure, you can have what's called a member managed LLC, meaning that all the members are also managers. Frequently that causes more issues for us in our situation. So we almost always name a manager to serve as the manager of the entity. So you're going to have members who are the owners, and then you're going to have a manager who is the decision-making power. Conceptually, if you have clients that are familiar with partnerships, it's easier to explain it to them in the sense that the member is essentially a limited partner, and the general partner is essentially the manager. The difference being that typically with a general partner, the general partner is going to have an ownership interest in the partnership. Here, with a manager in an LLC, the manager can be a member, but it does not have to be a member. So again, you can have 100% ownership by members A, B, and C, and you can have manager being D and not having any ownership at all. And the manager, D in my example, effectively would function as the general partner would in a partnership, making all the decisions. Going down to the partnerships, it's important to note under Florida statutes, again, that a general partner can be both a general partner and a limited partner. One item to note on that is, and we'll get to it in a minute, is that you could have potential exposure for your limited partner interest if you are also a general partner. So as far as forming an LLC goes, Secretary of State's website, sunbiz.org, very easy to follow, extremely simple from Florida standpoint. For LLC formation, you file the articles of organization. To do that, you need to have a name and address, a registered agent, and list who the manager is, etc. You do not have to have an operating agreement, but it's certainly best practice. We always try and have operating agreements for our clients. If you don't have an operating agreement, you're going to be relying on the statute for the default rules that will apply with respect to how the operation of the LLC is going to occur, like what the manager's rights are, what the obligations are between the members, things like that, like you see there. Those can all be specified in the operating agreement. Now, there are a few provisions when you check the statute that you cannot contract around, meaning that I can't change that. And a lot of it goes to fiduciary obligations and things like that. Everything else, for the most part, the default rule is stated in the statute, but you are able to contract around that in your operating agreement. Statement of authority is a concept for LLCs in Florida, and that's especially important for LLCs that own real property. The statement of authority is a statement that can be filed, which specifies who has the authority to take certain actions with respect to the LLC. So again, if I have an LLC that owns real property, I can file a statement of authority that states that only I, individually myself, can have the ability to sign any mortgages with respect to that property. So it helps to prevent fraud with respect to the property. What you would do is you get a statement of authority from Secretary of State, and then you go ahead and send that in for recording in the applicable county where the property is located. And that puts prospective purchasers on notice with respect to the fact that they would have to contract with me to handle anything with respect to the LLC and mortgaging the property, and that they don't have the ability to do that with anybody else. So with the LLCs, the filing fee, $125, annual report fee, $138.75. So it's not a significant cost. And again, if you're talking to your clients about this, if you have a single member LLC, meaning it's 100% owned by, say, a client or the spouses together, That LLC can be treated as disregarded, meaning that it doesn't have a separate filing obligation from a federal tax standpoint. So it might be that you're not even creating an entity that costs more in the sense of annual filings for tax returns, depending on how you structure it. All right, turning to the limited partnership formation. One thing to note, just kind of off the bat, is the LP filing fee, $1,000. LP annual report fee, $500. So with an LLC, the filing fee is $125 and the annual report's $138. So 1/3 the cost to maintain it and 1/8 the cost to open it. So unless a client has a specific reason to use limited partnership structure, I would suggest that most clients would be using LLC structures simply because it costs less to form and less to maintain. And from a tax standpoint, from a federal tax standpoint, an LLC, like I said, can be treated as, they'll like to be taxed as a partnership. So it's going to have the same taxation. So unless there's a given reason for it or a specific reason for it, most clients in our situations would prefer to have LLCs. But again, with a limited partnership, if you are going to form it, you have to file a limited partnership certificate, and same idea, limited partnership name, the address, registered agent, and the partner's information. Again, limited partnership agreement's not required, but you want to have that there for specificity. Makes life easier for everybody involved when there's an issue. All right, so with that, we're at 11:17, so I'm going to swing back to a polling question. And polling question number 2, who is Will Johns? Is it A, Eric Clapton's nephew, B, George Harrison's nephew, C, an amazing blues rock guitarist and recording artist, D, Mick Fleetwood's nephew, or E, all of the above? So I'll give you a minute to think about that. I will slide back to where we were so that we're ready to go. All right, and the answer was E, so happy Elephant Day. And again, in honor of Elephant Day, let's do one more quick one. How do you get down from an elephant? How do you get down from an elephant? You don't, you get down from a goose. So there we go. Things are getting better all the time. All right, moving on, we have limited liability partnerships. As I mentioned earlier, these are normally for professionals grouping together. What it does is it allows the partner to not be personally liable for the obligations of the LLP or other partners of the LLP. They are still going to be personally liable for the partner's own wrongful acts or for the wrongful acts of someone under the partner's direct supervision. All right, so it helps to limit some liability. Again, it's a situation where if you're in a group in a professional practice, that this would be applicable. All right. With limited partners, again, the general rule is that the general partner is personally liable for the debts of a limited partnership, but a limited partner is not. The limited partner has no control over the business. That's the rationale behind not enforcing the debt against a limited partner. There's an exception in that the limited partner, if they exert too much control over the business, that they can be liable for the business. And so the statutory rule for that is that the limited partner is not liable for obligations unless, so a good double negative to start our evening with statutory rules. Limited partner is also a general partner. So if I'm a limited partner and a general partner, I could have exposure as a limited partner because I'm also a general partner. That makes sense. Or the limited partner participates in control of the business, and we'll get to the control in a minute. And so it's a two-part thing here. Limited partner participates in the control of business, and the person suing who transacted the business with the partnership reasonably believed that the limited partner is a general partner. And that's based on the conduct of the limited partner. So you need to have this justifiable reliance prong to be liable as a limited partner. With respect to control, safe harbors, so if you are in one of these situations, you are not participating in control of the business. So this is a safe harbor, meaning that if I have an issue, I don't have an issue really in that I'm not a limited partner participating in control of the business, the first prong of the second test here. So to satisfy that, I would not satisfy it, for instance, if I was an officer, director, or stockholder of a corporate general partner. So you can look through that in case you're in a situation where it is an issue for your client. It might help them sleep a little bit better at night knowing that they don't have liability as a limited partner because they're not participating in control of the business. All right, so creditor applications, charging order entities and other porcupines. I missed an opportunity here with it being Elephant Day. I could have said charging order entities and other elephants in the room. As a side note, I would like to point out that porcupines also do have a national day. For those that are interested, it's July 2nd. All right, so charging order entities, limited liability companies and partnerships and jurisdictions have charging orders. Not every order or jurisdiction has a charging order protection. You need to check if your state does. So what is a charging order protection? Charging order basically means that if I am a member of an LLC and I have a creditor, that the creditor is limited to getting a charging order from the LLC, meaning that if the LLC makes a distribution to me, the creditor can obtain that distribution, but the creditor can't force the LLC to make the distribution to me, and the creditor can't access the assets of the LLC. So that's kind of the distinction there. So if I'm in a situation where I don't have that charging order protection, what should I do? And the way to protect yourself in that situation is to make sure that you do not have the voting control. So typically, what we would do is we would give our clients half of the voting control, and half of the voting control would go to an irrevocable gifting trust with somebody else serving as trustee. And then that way, if there's no charging order and the client gets a judgment against them, the client themselves don't have the ability unilaterally to make a distribution from the LLC because they would need the consent of the other member with the split of the voting control. So that's something to think about, and we'll talk about that more in these following slides, with some examples as well. One case to know about, Wells Fargo Equipment Finance Inc. versus Rederath, I believe is how you pronounce it. The nutshell here is that Jason Rederath was a debtor of Wells Fargo. Jason had an ownership interest in an Iowa LLC, excuse me, and Jason and Anaya claimed that their ownership and interest in the LLC, the Iowa LLC, was owned as tenants by the entireties. And so what's the importance of this? So under Florida law, if I am a husband and wife, so my wife Karen and I were married, still surprisingly, some would say, but it goes back to the 3 children thing, and I think anybody with 3 children can appreciate that. On a side note, again, not to diverge, but with 3 children, we have a middle child. This is also National Middle Child Day. But the last thing I was going to do was tell that anywhere near anything that could come back to my middle child just to make her feel more important on her specific day. She already does that well enough by herself. So anyway, so back to the husband and wife. Husband and wife own an asset as tenants by the entireties. If I get sued, they cannot look to a tenants by the entirety asset. That is a different asset because it's owned as tenants by the entireties between me and my wife. It is not owned by me individually, and therefore it is not subject to my creditor claims. So in this situation, the debtors were claiming that their interest in the Iowa LLC was owned as tenants by the entireties. The problem is, as the court explains, and it's a very well-written decision, but if we go back towards the end here, the paragraph in this case, the middle paragraph here, under Iowa law, the problem is that the LLC exists under Iowa law. The creditor remedies are also limited by Iowa law. And the court held that because we're dealing with an LLC that's located in the state of Iowa and formed in Iowa, that Iowa law would apply. And the biggest issue is that Iowa law does not recognize the ownership of property by a married couple as tenants by the entireties. So therefore, the court treated the ownership interest as having been owned solely by the husband, and therefore it was subject to the creditor and the charging order that was applicable there. So it's a choice of law issue. It's something to be aware of. Maybe, it's when you're looking at states, if you're dealing with states where you're actually working in them, you're going to have a little bit less flexibility. If you're dealing with states maybe where the real estate's owned, there might be a little less flexibility. But if you're dealing with states where you have investment LLCs or other items like that, you definitely want to pick LLCs in states where you could have that tenants by the entirety protection. You know, we use Wyoming frequently. In addition to Florida, one benefit of Wyoming is that you have additional anonymity. If you look at the Secretary of State website, there's no information on there regarding who's serving as the manager of the entity or anything like that. Unlike Florida, where you do have the information regarding the manager. But in either state, you can have the tenants by the entirety ownership, so that if the court applies Wyoming law, because let's say the contract that was violated, you know, arose out of Wyoming and Wyoming law applied, at least under Wyoming law, there would still be this tenants by the entirety ownership. So again, it's important to remember and to think through as well. And it relates both to charging order from a voting control standpoint with respect to what you want to do there. And it also, with respect to how you're going to own your assets and where you're going to place them with respect to the state law. And if you can have that ownership interest as tenants by the entireties for the protection or not for a married couple. All right, so briefly for charging orders, traps for the unwary. Again, like we talked about, not all states recognizing charging order protection. A court in the state of residency can apply the law of that state and not the law of another jurisdiction to determine if it applies. So again, that's like in the example of, let's say, if Iowa, in our last example, it was to the tenants by the entirety portion of the prong I was talking about, not the charging order. But if Iowa didn't have charging order, then the court would say, okay, we're applying Iowa law and you don't have charging order protection because they were applying Iowa law. So that's the concern there. Is that it's not just the fact that I have charging order protection under Florida law, it's where am I going to actually have the charging order protection, and it's not going to be applicable in the state that the judge picks. Again, if the non-debtor members has at least 1/2 the voting rights, they could seize control. So you want to get rid of, you know, half or even more if that's possible. And then the last thing, and this is more of a technical item that goes to the operating agreement or the partnership agreement. And this is from the Eman case. In Ray Eman came out a few years ago, probably about 10 now. That makes me feel old. Is that charging order does not apply if you're in bankruptcy and the operating agreement is not an executory contract. An executory contract means that you have affirmative duties, meaning that there's obligations that the partners or the members have to each other that they still have to perform for each other. And that obligation to perform, you know, that the people would not have entered into the operating agreement with each other if that obligation was not going to be performed. So that could mean like additional capital calls. It could mean the obligation of attending meetings. It could make the obligation of attending, making certain votes. You know, so those are items that you can add to your contracts or your operating agreement or your partnership agreement, so that the members or the partners, and especially non-voting members or limited partners, have affirmative obligations that they still owe to the other members or the other partners of the entity. So that'll help provide that protection if you are ever in that situation in bankruptcy, so that you can make the claim that you still have an executory contract. Again, that's in Ray Eman. I believe it's EHMANN. If you want to look that up, there are several articles have been written on that and examples as to how to help beef up your operating agreements and partnership agreements if that's applicable with respect to that. All right, so a very basic asset protection example. You know, client has revocable living trust, and originally client owns 100% of business or investment LLC. Maybe what happens then is that client transfers a 0.5 voting and a 2.5% non-voting interest to the irrevocable trust for children. That would be a trust that the client is not the trustee of. So they could have somebody like Alan as trustee, or your CPA as trustee, or your brother, or whoever you want as trustee. What's important to note is that the client can retain the ability to remove and replace the trustee of the irrevocable trust at any time and for any reason, and appoint an alternate individual. There are limitations on who could be appointed, but the client still has the ability to change the trustee. So if they appoint me as trustee and they think I'm going rogue and not making good decisions with respect to the business or investment LLC, because I do have 0.5 of the voting control as trustee of their trust, they can replace me with their CPA, for example. All right, and in this example, we're showing that 96% of the entity would be put in a Nevada trust. The reason that we would put it into a Nevada trust is that under Nevada law, I can create a trust for my benefit that's created from my, or protected from my creditors. If I live in Nevada, that's great. If I live in Florida, I'm in a similar situation to what we just talked about for the charging order protection and for the tenancy by the entirety's application of law, is whether the court will apply Florida law or will the court apply Nevada law. And so typically we would use the Nevada trust. We would have client put the Nevada trust interest or draft the Nevada trust rather, so it would be held for the benefit of the client's children. We would provide a provision that if the client's net worth fell to a certain level, that in the future that the client could be added by trust protectors. That's the safest version. For some clients, they're immediately addable, and some clients are okay just being a discretionary beneficiary right now. But by having the LLC with multiple members, you're going to have the benefit of charging order protection. And by splitting the voting control, if you're in a situation where you don't have charging order protection, you're still going to have some control. One item I'd like to mention real quick, because I just kind of glossed over it, is the multiple member. If you're in Florida and you are a single member LLC, then the charging order protection does not apply. So for Florida, for charging order protection, I need to have a multiple member LLC, meaning more than one member. So in this example, I would have a multiple member LLC because I've got myself, my revocable trust is one member, and then the two other trusts, the Nevada trust and the irrevocable trust for children, are treated as two members. It's important to note too that from a federal tax standpoint, the irrevocable trust for children and the Nevada trust can both be drafted so that they're ignored for income tax purposes, meaning that I'm not generating additional tax returns. I'm not even creating a partnership at the business or investment LLC level, because everything is treated as being owned by me for a federal tax purpose. But from a state law protection standpoint, from a state law creditor standpoint, this LLC has 3 members. And if I'm in Florida, I have a multiple member LLC, meaning I now have the full charging order protection, and I do not have to worry about having a single member LLC. All right, so we're at 11:32, so I am going to go back to one more polling question right now. And here we go. Why wasn't Alexander Hamilton able to be US president? A, he did not read the Thursday report. B, he did not use the State View software. C, he was not supported by Ernie Dover. D, he was born in Nevis and not a US citizen. And there really should be E, and maybe it's just the fact that he liked elephants, and that could have been enough of a reason back then. So we'll give you a minute to go ahead and answer the polling questions. I am going to get us back to where we were. So here we are, 42 is our next slide. Now, before we get into this, I do want to mention one thing, which I found fascinating, is that, I was doing the legwork trying to figure out, and legwork's not a good joke, I could have done a better pun there, about elephant days. And it turns out that elephant jokes were really popular back in the 60s. And so in addition, and I'm going to go to my paper for this. So there was Isaac Asimov, who wrote The Foundation. He was a Foundation, many other books. And as one of his quotes is that he found that elephant jokes were the favorites of youngsters and unsophisticated adults. So I'd like to think I checked both of those boxes, which probably explains why I enjoyed finding these elephant jokes. So the one thing about elephant jokes, and especially back in the 60s, is that they would build on each other. And even if they were irrational, it didn't matter. So a good example that I found is, why do elephants wear sandals? And the answer is that they don't sink into the sand. And the follow-up to that is, why do ostriches bury their heads in the sand? And the answer is, they're looking for the elephants that didn't wear sandals. So that, my friends, is a classic 1960s elephant joke that Isaac Asimov would have found unsophisticated, but to me is funny. So moving on, separating assets and functions. So here's another idea that we can use with the LLC structure. Originally, we had Smith Family Holdings LLC, and the entity itself had all of the construction and electrical, the service and repair, and the sales group. They were all together and exposing each other to unlimited liability. By creating subsidiaries underneath Smith Family Holdings LLC, we can have 100% owned subsidiaries, Each of these subsidiaries then should be firewall protected from the others. So if there's liability associated with the service and repair work, it wouldn't go to the construction and electrical and vice versa. And so in addition, what you're able to do by forming this structure with the subsidiaries below it is that you're able to do this in a way where you're not creating, again, additional, much more additional work. You might have some additional tax returns just depending on how it's structured and what the entities are. But you do have the protection from the liability standpoint, which is obviously a huge feature on this. And you're able to do this in a structure where you should be able to do it with minimal tax effects or tax impacts, at least from a federal tax standpoint. And in addition, you're able to segregate the assets out, like I said. So that's really a great idea for the structure to help segregate out for the liability. And it doesn't really matter who the ownerships are or who the ownership is. I mean, here we were just showing the 4 members. In addition, now Smith Construction Electrical LLC, maybe every 6 months, excess cash gets taken out of that LLC and put up at Smith Family Holdings LLC level. That should help protect that extra cash as well, so that if there is an obligation against Smith Construction Electrical LLC, the creditor can't look to the cash of the entity. And hopefully that firewall again would be respected. All right, so this is again the same concept, just showing in a different graphical form. All right, and now this is a similar idea of what we talked about, is that with Incs, again, there's no charging order protection except perhaps in Nevada for a regular corporation. So if I have an Inc, what I want to do is I want to make it so I have an LLC owning the Inc. This is the 368 A1F reorg. We've got our articles written on that. Again, it's 368 A as in Apple, 1 F as in Frank reorganization. If you Google that, you'll be able to see some of the articles that we have that explain this in more detail. But it's a way of doing the structuring so that you can have the LLC at the top layer being treated as, from tax purposes, essentially the equivalent of Smith Store Inc., what used to be the 100% thing that was owned by the entities. Now they own Smith Holdings LLC, so they have charging order protection because the LLC owns the Inc. With this being an S Corp, you can have the Q sub underneath it. You're not going to blow your S election. And in addition, now that you've got Smith Holdings LLC at the top, if you have other assets of Smith Store Inc. that are valuable, you're able to flow them up and down and put them into that possibly subsidiary disregarded, so that you can get some of the assets out of Smith Store Inc. so that if there is a creditor situation, those assets are not exposed. All right, now the advantage of the over easy arrangement. So this is again the over easy arrangement that we talked about, Smith Store Inc. becoming a subsidiary of Smith Holdings LLC. Number one, we don't need to change the name or tax ID of the sub-entity. That's huge for a lot of people. Maybe not for Smith Store Inc., but if you're in the medical situation where you're doing billing and things like that, and you're trying to do any kind of reorganization, the last thing you want to do is have to change tax ID numbers, et cetera, for the entities. In addition, the new parent can loan money to the subsidiary and receive a lien on assets. The new parent can own assets for buy-sell purposes of the subsidiary, such as life insurance that wouldn't be exposed to any creditor of the subsidiary. The parent, and this is a big one, can be formed in another jurisdiction to better creditor protection. So it's a great way to do it as well, to provide some additional protection. All right, so disadvantages, you have the cost of the new LLC, the cost of maintaining the separate LLC, and the coordination of the transition. So there is going to be, some legwork in getting this done, but it's a way of, if you're in a situation already, it's a way of making it into, reforming it, let's say, into a different situation where you're going to have more creditor protection and more benefit. So I know we have Ernie coming on in a couple of minutes. So what I'd like to do first is, we're going to do that last polling question. So we get our 4 polling questions in, and then we will continue going through this until Alan and Ernie come back on. So the last polling question, would you like to be a beta tester for Estate View? No, I like beta fish, but I wouldn't give them artificial respiration. No. For B, I'd rather have a babel fish. C, yes, it seems like it would be very helpful. D, yes, and I would like a beta fish as well. And E, all of the above. So we'll let you answer that, and we'll go back to where we were. And let's see, do I have any other good questions? I do have a couple more, just the last couple of jokes, I promise, okay? What did the grape say when the elephant stepped on it? Nothing, but it did let out a little wine. I mean, that's a classic. And why couldn't the two elephants go swimming together? They only had one pair of trunks. There you go. And then the last thing is, why did the elephant leave the circus? And the elephant was tired of working for peanuts. So that's the end of the jokes for the day. So we had the disadvantages of the over easy arrangement, and this is again what the over easy arrangement is. Very simple. Smith Store becomes a subsidiary of the parent at Smith Holdings level. As far as looking at it again, this is the same idea, the same structure, dealing with a professional practice, teasing out the real estate. You have a triple net lease, you're able to use this structure. They can own, the entities can own money up to the family LLC. You could place a new parent above the Q sub or the practice. That's going to own additional money. So again, these are ways of just taking money out of the entities that could be exposed to a creditor situation and structuring it in a way so that the family LLC is more protected. All a good thing for the clients. All right, so again, using the assets for the otherwise all exposed. So this is the idea that client has $5 million in a building, lender's willing to loan $4,500,000 on the building. So in this situation, lender loans the money to client. Client then contributes that money to LLCB. The LLCB can then be gifted to an irrevocable trust for spouse and descendants. The building itself has a mortgage, held by a friendly creditor. Now the building being held by the friendly creditor, that's fine. And then you have the guaranteed note and to the lender for the $4.5 million. So this is a situation, it's a way where if the building, if someone was actually going to slip and fall, get sued, and they're going to get sued on the building, they stripped out the equity. He's got it in LLCB where it can benefit the spouse and the children. So that even if they get in a situation where they end up with liability on LLCA, they still have all the equity out in LLCB. So it's a way of definitely benefiting the client. And again, this is the equity stripping example. And this is a good situation because for us to be talking about as we're dovetailing into the rest of the presentation. So in this situation, we're talking about John having $3 million worth of rental houses, and he wants to put $2.6 million aside in an offshore trust. So Bank of Offshore sets up a Delaware company called ABC Lenders, and John establishes an offshore trust with Bank of Offshore called DEF Trust. And ABC Lenders puts $2.6 million into the DEF Trust account, which John can direct the investments into CDs and other items. The parties sign agreements so that there's a mortgage of public record owed to ABC Lenders, and it's secured by the mortgage on the property. So basically what John's done is he's taken his $3 million property here in the US and he used that as collateral to receive a $2.6 million loan, which was placed into an offshore trust for the benefit of John and his family. And the benefit of that is that in this situation, the financial statement shows John $3 million in properties, $2.6 million in mortgages, and that he's only a discretionary beneficiary of the 2.6 offshore trust. If he does get into a creditor situation, because he's only a 2.6 beneficiary, discretionary beneficiary is the key word there of that trust. He's the discretionary beneficiary of that $2.6 million trust. That's obviously going to be very hard for a creditor to get access to. He's got $400,000 worth of equity in the property, and maybe after everything he settles for just the $300,000, part of the equity that he had in the property. And because of that, it's difficult for the client to get to that offshore $2.6 million. And that'll help the client to live, after the creditor situation with the standard they're used to based on the assets that they have. All right, so again, here's the pictorial version of what we just talked about. Rental houses, ABC Lenders, 2.6 mortgage, that gets put into the DEF trust for John and family. And we're looking at the value of what gets protected in that situation. All right, let's see. Friendly judgments, I'm gonna pass that for right now. The ELOP system. The ELOP system, now again, this is what we were talking about before, about using the LLCs in the structure or so that you can have this separated liability. And the reason we're saying LLCs in this example is we have a parent S corporation, meaning that it's not a partnership. So I can't have a partnership because obviously a partnership's tax is a partnership. But one of the nice things with an LLC, like we talked about earlier, is an LLC can be treated as a partnership if it has multiple members, or it can elect to be treated as an S corporation, or it can be treated as a corporation. So we're able to use LLCs in this example here. We have the parent S corporation. That probably is what was formed after, because originally the medical practice entity probably was the original only entity that the client had when they came to us. And what we end up doing is that we create the parent S corporation up at the top, the new parent F reorganization, like we mentioned. You keep the key sub medical practice entity, which again retains its EIN and everything else for billing purposes. That's going to own the furniture and the unsold accounts receivable. Then maybe you have a factoring corporation, which would be a separate entity. It could be owned under the parent S corporation, but the factoring corporation is going to help for letters of protection. And then maybe there's a management company that gets paid management fees. So again, by segregating out all of these assets and by taking money out of the subsidiaries, making them less profitable, making them less easy picking for any judgment creditor to look at and try and get access to. All right, so we'll go into the tax planning and see how far we can get. So tax exclusive nature of estate and gift tax. So again, this isn't necessarily related directly to LLCs and LLPs, but it is something to understand. With the value of the estate, $10 million, and value of the estate after deducting gift and estate tax, $10 million and the estate tax. So here what we're saying is we've got a $10 million gift, or $10 million estate. And so in the no gift column, I don't make any gifts. So on my date of death, I have $10 million. If I have a 40% estate tax, then we're going to have $6 million of the estate left, and that's what the family is going to get. In the above situation, if I make a $2 million gift, I'm going to be using 40% of the estate. If I pay tax on that gift, the $800,000 means that I pay $800,000 on my $2 million gift, leaving me with $7,200,000 worth of an estate. With the estate tax in that example, $2.8 million, the value of the estate, 4.3. You can see from the math that the family actually gets more of a benefit by making the gift during lifetime if they were going to otherwise be subject to estate tax. So, and Alan, are you ready to take over? Or should I keep going? I will keep going. All right, so what we've got here.
No, stop. Sorry about that, I was muted.
No problem.
Hello, Ernie, how are you?
I'm doing well, thanks, Alan. How about you?
I'm doing good. We got a sound issue. What's your thought on that, Josh? Good. Okay. Ernie, you want to tell us a little bit about yourself?
Sure. Ernie Dover, tuning in from Nevis in the Caribbean. I moved to Nevis a little over 29 years ago. Prior to that, I was in the Isle of Man for 9 years. In Nevis for 22 years, I managed One Star Holdings for a trust company, which together are the largest corporate service group on Ireland.
Ernie, I'm gonna have to interrupt you. I think, do you have a speaker on? Because we're getting feedback.
I don't just have a speaker.
I wonder, Josh, should he turn off his computer and just call us on his phone? Yeah. Sorry, Ernie, if you want to just call us, call in. You have a phone number?
It's no problem.
Yeah. If you want to maybe mute yourself and then call in.
Yeah.
And then, Ken, you want to cover a little bit more while we wait for Ernie? Or should I? Josh, I guess Ken left. Okay, so can I share my screen? Okay. Am I sharing my screen? Okay. So while we wait for Ernie, and I apologize, it's our fault because we should have tested this, but in any event, the charging order protection that we are very often looking for, and which the Rittereths were able to have both in Iowa and in Florida, may be much better outside of the United States. One important reason being that the creditor would have to go to the jurisdiction where the LLC is to try to get into the LLC entity. So the offshore jurisdictions, including Nevis and the Cook Islands, have put together, with the assistance of Jonathan Gassman and others, have put together some nice legislation which makes it difficult for a creditor to get into a Nevis LLC. And Ernie Dover has been a trust banker in Nevis for over 25 years, and he and I have worked together quite a bit, and hopefully his sound will work good soon. I will also mention that Nevis, the Cook Islands, and at least 20 other jurisdictions have specialized legislation, which basically says if you come to our jurisdiction and you open an irrevocable trust for the benefit of yourself, and a creditor comes along later, not necessarily at the time you set up the trust, by the way, but a creditor shows up later, generally a creditor that you didn't know about or expect at the time you set this up, then the law of the jurisdiction is not going to allow that creditor into the trust, even though the client who sets up the trust and funds the trust is a beneficiary. So one of the things that Ernie's firm does, and that his prior firm that he was with does, is enable US citizens and people from all over the world to set up these trusts. And the advantage of an offshore trust over a Nevada, South Dakota, or Alaska or Delaware trust is that we can't be sure whether, for example, a Florida judge would tell me, Alan, I know you set up this trust in Nevada. I know you set it up before you expected a creditor. I know that Nevada law says your creditors can't reach in, but you're in Florida, and the broker who handles the assets in the trust is in Florida, and the creditor's in Florida. So I, being a judge in Florida, hereby declare that Florida law should apply, not Nevada law. So then there is something called the full faith and credit clause of the US Constitution. And the full faith and credit clause of the US Constitution says that if a Florida judge makes a decision called a judgment, it is to be fully enforceable in the state where the situation is involved if it's a legitimate judgment. So then you get into the question. Here I just heard something. Ernie, is that you? Okay.
You hear me now? Good.
There are 5 of you.
I can't really say too much about that.
Oh, perfect. Now I hear you. Great. So as I was saying before I turn this over to Ernie, another question is, for creditor enforcement purposes, does the full faith and credit clause apply? And when you go to the Cleopatra case, and when you go to some older US Supreme Court cases, there have been indications that even though Florida law may apply to me and my creditor and my assets, Nevada law will apply for purposes of creditor rights. So there's no case law on that. So if you want to be more sure that your assets are going to be protected, you would go offshore. But the downside to going offshore is you have to deal with Ernie, who's just a terrible person to have to deal with. That's the main reason. But then secondly, you've got a lot of IRS compliance and a lot of international trust compliance. So Ernie, this is, I apologize for the sound problem. This is a 60-minute program, but everyone who's on this program is going to stay on probably another 5 minutes. And then a lot of people are going to leave because there's not going to be continuing education credit going forward, but a lot of people are going to stay. So Ernie, as you know, this is a presentation on LLCs, and you're an expert, not a lawyer, not an accountant, but a practical expert on LLCs. What should we know?
Well, I think you've hit the nail on the head a little earlier when you focus on things like creditor protection and in particular charging orders. A charging order well, first of all, Nevis, it's in the Caribbean. We're part of the Federation of St. Kitts Nevis. The island of Nevis has a lot of autonomy from the federal government to allow us to promulgate laws locally here in Nevis, not dissimilar to the US federal model. Nevis LLCs have been in existence since 1995, so they're certainly not a new product. Nevis is a jurisdiction, entered the quote-unquote offshore arena in '84, and has unashamedly gone down the road of asset protection. Although we have IBC legislation as our primary legislation, we also have LLC legislation, we have foundation legislation and trust legislation, and both the LLC and the trust legislation are unashamedly geared towards asset protection. As it relates to Nevis LLCs, our charging order provisions are pretty interesting and pretty useful, I think, here, in that Nevis does not recognize foreign judgments or foreign orders in most instances. If you want to get a charging order against a Nevis LLC, mostly you will have to come to Nevis to apply for that charging order. Even before you get in front of a judge, you will be ordered to put up a bond secured by a local bank here in Nevis. You can't simply say, I've got $1 million at Bank of America or Daiichi Kangyo in Tokyo. You need to come get a bond in place. The quantum of the bond will be determined by the judge in Nevis, depending on the likely costs and expenses of the LLC or the LLC member. You have to overcome all of those hurdles to even look for a charging order in Nevis. If you're lucky enough to get a charging order, it's going to expire after 3 years with no provisions to allow a charging order to be continued. A charging order does not grant the holder of the order any interest in the LC in Nevis. It does grant an order where they may benefit from any distributions from the LC within that 3-year period. But of course, if the LC is properly structured and properly managed, and unless there's something within the operating agreement, which is something which is pretty rare, then you're going to find this simply by not making any payments from the LC, any charging order is going to be defeated. And that, in a nutshell, is Nevis charging orders. I think certain US states have certain provisions, but the whole idea of having to come outside the United States to lodge a bond, to try and find a local bank with whom you can work to put that bond in place. There are a lot of hurdles and a lot of obstacles which are not necessarily put in place to be obstacles and hurdles, but clearly as a jurisdiction, we need to ensure that whatever entities we have here are well supported in legislation and regulation, and our charging order provisions are certainly a significant component of that.
So Ernie, for a client who may want to hedge their bets and not do everything in Nevis, what other jurisdictions are notable for LLC legislation? The Cook Islands, any others?
Alan, I'm in a curious position in that although my firm provides IBC, LLC, trust and foundation services, we are basically guided by professional intermediaries, and they will be the ones who will determine which is the best jurisdiction for their client. Clearly, the Cook Islands and Nevis for LLCs and trusts are probably regarded as the two preeminent jurisdictions. Other than that, LLCs outside the United States, they do exist in other places, but probably don't have the same quantum, probably don't have the same legislative involvement in terms of making sure that the product is a competitive one. I believe the Isle of Man may have LLC legislation. I believe Belize may have went down the road of LLC legislation at one stage, but the options outside the United States, it's not as if an LLC is something you can pick up the same as a corporation wherever you go. An LLC is a very specialized piece of legislation used almost exclusively by American clients because of the options on taxation. And really the number of jurisdictions offering LLC services are pretty small.
Okay, and I just want to point out for the viewers, if you go to the IRS Form 8832, you'll see specifically a list of countries and entities that can elect to be disregarded for income tax purposes, or can be partnerships or C corps. You could use your offshore LLC. You can use your Form 8832. You have to file it unless you want that LLC to be treated as a C corp. You have to be knowledgeable in this area, but it is not rocket science. It's important to get it right, but fortunately, it is, as I said, not rocket science. Now, Ernie, I know at one point the Economic Union in West Europe was pressuring Nevis to tax these LLCs. And there were, I think, bulletins from the government saying that that might have to happen. Did that go by the wayside?
Basically, St. Kitts Nevis, like a lot of jurisdictions, we came to a crossroads a couple of years ago because the European Union and the G7 nation, or however many there are in the G at the moment, it's always difficult to know, they arrived at the concept that every entity should be taxable somewhere. And for jurisdictions such as Nevis, such as the British Virgin Islands and some others in the region, we were faced with a choice of either taxing entities or having the entities submit a tax return within our jurisdiction, which indicates that they're managed outside the jurisdiction and therefore are not subject to local taxation. It's not a great situation at the moment in that although a Nevis LLC will be established, a tax return will be filed. The tax return is an informational return if the entity is not managed in Nevis. You simply give the address outside the jurisdiction where the entity is managed, and that information is not shared with tax authorities elsewhere. We have gone down the road that if we do this, if we have the entity sign a tax return indicated they're not taxable in Nevis, then nobody would want to be taxable in Nevis, because if you opt for taxation in Nevis, your entity is going to become taxable at local rates of up to 33% on all worldwide income. So we've taken the view of, if you will, taking a step back from the fiduciary responsibilities within an LLC and reverting to being something of a corporate domicile, whereas other jurisdictions like the British Virgin Islands are touting their zero tax regime, that you can elect to have an entity in the BVI taxable as a local entity at 0% tax, provided you have substantive mind and management within that jurisdiction and you pay a quite significant price for your mind and management. But of course, as far as I'm aware, the British Virgin Islands does not have LLC legislation.
Okay, so Ernie, I want to make sure I cover your economic citizenship or residency opportunities and just the very big 30,000-foot picture on asset protection trusts in Nevis. But before we go to those two subjects, is there anything else you want to mention in the LLC area besides telling us what someone would expect to pay to at least pay the government of Nevis to set one up, and then annually thereafter, and what kind of information has to be disclosed?
Okay, well, let me start by answering those particular questions. Most providers in Nevis will work with you to establish an IBC or an LLC for $1,000 to $1,200, maybe a little less. The LLC tends to be a little less expensive because we know that our competitor is a very competitive domestic market in the United States. Our firm will establish an LLC for $800, which includes government fee and registered agent fee for the first year. Renewal is going to be $250 for government and an agent fee, which is currently $400 a year with us. You can also opt to have us provide a service to assist in filing the tax return or a mail forwarding service. But the bottom line is you can form an LLC in Nevis for less than $1,000. You can maintain the LLC in Nevis for $700 or $800 a year. There is a tax return to be filed, but it's an informational return, doesn't include any financial information. When you're filing your LLC in Nevis, the names of the members and managers are not declared or disclosed on the public record, nor is your LLC operating agreement. To form an entity in Nevis, you simply put together a 2 or 3 page set of articles, which in the most generic sense, allowable by law, allows the LLC to do anything which is legal. The only name on the LLC is that of the organizer, which is typically one of the staff within our office.
Okay. Now, I don't think it's necessary, but some lawyers in the United States think that a Nevis lawyer or a Nevis law firm should bless the arrangement in an operating agreement. What would you expect to pay a Nevis law firm to send an email saying, yes, this is okay?
That is a very, very good question. Not something I have done because we find that in most instances, I mean, our legislation is pretty generic in a lot of areas. It's more important to most clients that the LLC and the operating agreement and the provisions work for them from a domestic perspective rather than from a Nevis perspective. If somebody wanted a set of articles or an operating agreement blessed or reviewed by a Nevis attorney, I think a set of articles you could probably get a legal opinion for $800 to $1,000, an operating agreement maybe about twice that. But in reality, the key to the whole thing is making sure that it works for the client from a domestic perspective.
Right.
You're dealing with a lot of templates, articles here. When entities are formed, they've been tried and tested over so many years. If a client wants something a little bit different in an operating agreement, or if they want the articles to be something rather than the generic, then a lot depends. A 3-page set of articles might cost $800 to $1,000. If you decide that you want your articles to run pretty much like a private placement memorandum and run to 100 pages, then you're likely to be paying hourly rates of $300 to $400 an hour, however long that takes.
How many law firms or how many lawyers are there in Nevis?
I would say in terms of lawyers in Nevis, maybe about 25 or 30. But you probably only have about 3 or 4 law firms in Nevis which have any more than 2 attorneys. St. Kitts is the larger of the 2 islands, and although Nevis has its own laws, any lawyer admitted to practice in Nevis is admitted to practice in St. Kitts and vice versa. The lawyers in St. Kitts are also very familiar with the Nevis legislation, Nevis quote-unquote offshore legislation. So you do have possibly a couple of slightly larger firms over in St. Kitts, but I can only think of a couple of firms here that have more than 2 or 3 lawyers. You have quite a few in individual sole practitioner situations, but we don't have any global names here in terms of law firms, but yet we do have some law firms that have been here upwards of 100 years.
And am I correct that lawyers are not permitted to take a creditor's case on a contingency basis, and that it's difficult to find a law firm to pursue a cause of action when they've represented the trust company involved?
Yeah, well, certainly in terms of a contingent fee arrangement, that is something which is not permitted by the local bar association. Most lawyers will either charge by the hour or will enter into an arrangement where they will do a matter for an agreed fixed fee. Now, what's the difference between an agreed fixed fee and a percentage? I'll leave it to the lawyers to sort that one out. I'm not a lawyer. I don't want to get into those waters. But look, because it is a small community, because we have a small number of lawyers, quite often you will find that a lawyer or a law firm is going to be conflicted on a matter. If they've represented the registered agent, then some lawyers will say that they can't represent an LLC or can't represent a creditor because they've represented a registered agent. Others will say it's a step removed, so we're okay. I guess it's not dissimilar to anywhere else. It's really up to you to decide what you're comfortable with.
Okay. All right. Anything else you want to say about LLCs, or you want to switch to economic citizenship or trusts?
Well, you know, if you would have asked me about economic citizenship 2 weeks ago, I would have had a spiel about how wonderful economic citizenship is in Nevis and how much better we are than everywhere else. And then the European Union issued a directive a couple of weeks ago, which basically said that any jurisdiction which is offering citizenship as a product or citizenship for sale really needs to ensure that the citizenship is not just a passport for sale, that the country is gaining some real substantive benefit from the investment of the economic citizen, but also from the input of the economic citizen. So the result of that is that our government at the very end of July turned around and significantly increased the fees and prices payable for each and every economic citizenship option within St. Kitts Nevis. At the moment, we're out of line with the other 4 jurisdictions in the East Caribbean region because the others have yet to swallow the poison pill. But we all think it's basically going to be a state of flux over the next couple of months while everybody comes to terms with the fact that the European Union wants us to do this, and if we don't do this, there are going to be consequences. We really don't know whether at the end of the day we're going to be competitive, as competitive, more competitive. We need to see how everybody else changes the rules within their jurisdiction. So for now, if I'm trying to sell economic citizenship in St. Kitts Nevis, I don't know that I would necessarily be able to do that anyway well. So if I can't do it well, I'm not going to do it.
So what would it cost if I'm absolutely convinced that I want to be an economic citizen of Nevis and St. Kitts because I want a European passport? How much would I budget, and what do I need to do?
Well, being a citizen of St. Kitts Nevis will give you visa-free access to most of Western Europe, but certainly won't give you a European passport.
Okay.
At the moment, as an individual, if you want to make a donation to our country, the minimum donation has now gone to $300,000 for an individual. You're going to pay probably about $20,000 to $25,000 in fees on top of that. You also have the option of investing through real estate, where you can buy a condominium with a minimum value of $400,000, or a home with a minimum value of $800,000. Or you can invest in a new scheme, which is basically a scheme to invest into developing areas of our economy. One of which is the fact that we have a film industry which started developing here about 4 or 5 years ago. If you wish to invest into the film industry, and if you're investing into an approved product, then you can start a minimum investment into that is as low as $250,000. Is there a possibility of a return on that? Yes, it is a commercial decision to go into that. Government will allow citizenship to be applied for based on that investment, on the basis that the movie industry is not a traditional industry, and it's something which is bringing significant economic benefit to the country. I'm sure as time goes on, we will find further schemes like that. Anybody who hasn't been to the Caribbean or hasn't been to St. Kitts Nevis, you will see, particularly in Nevis, that it is one of the more unspoiled areas in the Caribbean. There is a real push towards ecotourism, green tourism, health tourism, medical tourism, and whatever down here. No doubt you will have some entrepreneurs who will manage to get some of their products and schemes approved under the citizenship regime.
Okay, so I got a little bit confused. So for $300,000 paid to the government and $25,000 paid to a law firm or you or somebody, I can get an economic citizenship, which would allow me to live there, visit there, and have travel rights throughout Europe. Is that what you said?
Yeah, pretty much so. I mean, the additional $25,000, it's not all for the agent or the lawyer. There is a $10,000 fee to government for diligence. There's a $250 fee to government for the application. You also have passport application forms once you've been granted your citizenship and whatever the case might be. But yes, for an investment of $300,000 plus professional fees, you can apply for and if successful be granted economic citizenship here. Gives you the same rights as any other citizen of the country, with the one exception that you cannot vote here. And I can't imagine that that is something that would really deter too many people not being able to vote in an election in a country you've never been to. Anybody who is a citizen has the right to reside here, to travel freely to and from. As a citizen, if you wish to invest in real estate here, you can avoid a 10% alien landholding tax, which has to be paid by non-citizens who are investing in the country. So if I, as a citizen, wanted to buy an apartment and Alan, as a non-citizen, wanted to buy the apartment next door, Alan would pay 10% more than I would for the apartment, simply because Alan has to pay as a non-citizen. If Alan wants to buy 2 apartments, 3 apartments, 4 apartments, then it's worthwhile Alan having a look at citizenship to see whether or not the cost of citizenship could possibly be offset by the saving he might make if he's going to become a developer or a landlord down here.
Okay. Were the costs recently doubled in the last few days or weeks?
Just about doubled. We introduced a program in St. Kitts Nevis at the end of December last year, became effective on the 1st of January this year, that for $125,000, it used to be $150,000, but for $125,000 of a donation, an individual could apply for citizenship. That 125 became 300,000 overnight. The fees on the real estate, it was that an investment of 200,000 in a condo or 400,000 in a home would qualify you for application for citizenship. Those figures doubled in that a condo has minimum investment went from 200,000 to 400,000. A home minimum investment went from 400,000 to 800,000. But it has to be acknowledged that when it comes to making your investment merely give you the right to apply for citizenship. Citizenship is not granted, and citizenship is not guaranteed. And we go through a pretty rigorous diligence situation here. We use, and that's the reason why there's a $10,000 fee on application for diligence. We use international agencies, depending on what region you're in, to carry out pretty detailed due diligence and background checks on each and every applicant. Each applicant is now subject to an interview, whether in person or virtually, with a government official, so that the government official can understand what you hope to gain and benefit from becoming a citizen, what you feel you can add to the country and whatever. So we've effectively gone from a passport for sale program, which is what economic citizenship has been amongst all 5 countries within the region. We're the first one to take the necessary step of going from the passport for sale to actually looking for citizens who are going to make a significant contribution to the economy.
Got it. Okay, so what about the offshore trust world? And you and I are going to have another presentation for a full hour on this, but maybe we can whet some appetites, and maybe your 5-minute elevator speech would be nice.
Trust. Nevis, that's pretty much our core market for asset protection purposes, LLCs and trusts. As I say, unlike places like the BVI in Panama, we have gone down the road of providing products within Nevis that benefit U.S. individuals actively looking to engage in asset protection, estate planning, etc., etc. The LLCs are widely used. But the changes in taxation here over the last number of years means that an LLC or an IBC managed in Nevis becomes subject to global taxation. That provision does not apply to Nevis trusts. You can have a trust established in Nevis with a Nevis-based trustee, and that entity, although it's managed by a Nevis-based trustee, it's outside the scope of taxation. So there is no taxation in Nevis by having a Nevis trust. I resist the temptation to call the Nevis Asset Protection Trust, because a trust which is well put together will provide asset protection as just one of the many facets and benefits of having the trust. But certainly having a trust in Nevis, there are no tax consequences, no consideration of taxation, no requirement to have an external party involved. A little like the LLC, you establish a trust in Nevis, you register the existence of the trust, you register the name of the trustee, the name of the settlor, the names of the beneficiaries, the protector. None of those are a public record. And unlike an LLC or an IBC where you have to file articles with the registry, in Nevis you don't even need to place a copy of the trust instrument on the public record. A trust and corporate service provider or an attorney certifying the existence of the trust is sufficient to have the trust registered in Nevis. Obviously, if somebody makes a mistake in believing a proper trust exists when it doesn't, that's a whole different situation and scenario. But the whole idea of being able to establish a trust in Nevis without having to make any of the details or any of the parties to the trust public, other than the name of the trustee, is certainly seen as a quite significant selling point. I know Alan is familiar with the Cook Islands, and give him another 2 minutes, he's likely to ask the question, is Nevis better than the Cook Islands? And I would say the two of them are very, very similar. One of the advantages of Nevis as a trust jurisdiction, not dissimilar to the LLC and charging orders, is that if you want to take an action against a Nevis trust, it must be done in a Nevis court. We don't accept foreign judgments, and there is a bond to be posted in Nevis which is set at $100,000 to even challenge a trust in Nevis. It's not a bond that can be set at the discretion of a judge. So you set up a trust in Nevis, and you have a 2-year period during which somebody can charge fraudulent conveyance or whatever the case may be. Once you're beyond that 2-year period, the strength of the lock-in on the trust is greatly enhanced. And I think, as I say, Nevis, Cook Islands looked at very, very similar, even constitutionally. I mean, Cook Islands it has a constitutional relationship with New Zealand, which I think any constitutional scholar would be hard set to explain. St. Kitts Nevis, we have, I think, a more pronounced constitutional link between the two islands. For anybody living on the east coast of the United States, having a trustee in the same time zone can be very useful, can be very beneficial. Our workday in Nevis is pretty much the same as yours on the east coast in the United States, which means that when we come into work in the morning, we still have a couple of hours to deal with banks or financial institutions in places like Switzerland or Western Europe, where you set up a trust in the Cook Islands and you're always dealing next day on any transactional matters, simply because of time zones. But our legislation here, unashamedly based on Cook Islands legislation, we've revised and revived it in a couple of areas. Alan, a little earlier, mentioned Jonathan Gassman, and between Jonathan Gassman and a gent by the name of David Neufeld, they have been responsible over a number of years to ensure that our trust legislation and our LLC legislation remains both fit for purpose and competitive.
Yeah, and let's give Jonathan Gottman a round of applause. He's done a fantastic job, not only on Nevis law with David Neufeld, who's a lawyer in New Jersey, but also Delaware asset protection trust law. And yeah, he's taught me a lot, and is a fantastic lawyer and a fantastic person. So Ernie, I'm going to go ahead and close this program on Nevis out and get to some U.S. estate tax planning. Is there you have any good final words for us? Besides that, the hotel in Nevis, the Four Seasons Hotel, is a gorgeous hotel, a very nice place to visit.
The Four Seasons Hotel is a very nice place to visit, absolutely. But really, to see Nevis, you've got to get out of the Four Seasons. It is, as Ken the comedian alluded to earlier, the birthplace of Alexander Hamilton. We have quite a lot of history here, both American history, British history. Admiral Nelson of Britain was married here in Nevis. At one stage, Nevis was one of Britain's main trading hubs in the entire Caribbean. We have, we believe, close to 400 great houses. The first commercial hotel in the region was the Bath Hotel in Nevis, right next to the Bath Spring, which is a hot spring which has a lot of therapeutic qualities. That's, you come to an island which is 6 miles by 6 and you think it's small until you realize Manhattan is not much bigger and there's plenty to do in Manhattan. But Manhattan doesn't have our weather.
Yeah, that's a great way to sum it up. All right, so we'll schedule a noon Saturday webinar in 2 or 3 or 4 weeks. And Ernie, thank you so much. And if anyone, Ernie, what's your email address? Just so everybody has it. And then if anyone wants to contact Ernie, I'll be glad to, send you an email as well.
Yeah, my email is just Ernie, ERNIE, at dovercorporate.com.
DOVERCORPORATE.com.
Yes, indeed.
Right.
We don't have a website, and we quite deliberately don't have a website. We are in the process of expanding our business. We have quite a few new staff either on board or coming on board. And it's always been my view, as I said a little earlier, if I don't think I can sell or service a product properly, I'm not going to offer to sell or service that product. I'm not going to look to mass market advertise or look to expand my business hugely until I'm confident that I have a staff that are well educated and well trained on all aspects of the service we're offering. And I just find once you have a website, you spend a lot of time dealing with a lot more queries than you're possibly equipped to handle. Right. I'm not in a hurry to grow my business, but I do want my business to be around. So I'll grow it slowly and I'll grow it right.
Yeah, perfect. All right, Ernie, thank you so much. It's always a pleasure. And thank you for the 3 trusts we're working on right now. It's fantastic to be able to call the decision maker and the kitchen, you're every cook in the kitchen right now. So that's a great experience for the client.
Alan, my audio was not great, but I hope you said every cook in the kitchen and not every crook.
Right. All right.
But it's been a real pleasure. And you have my email address. If you have any queries on Nevis, what you can and can't do, what's possible, what's not possible, you need a fee schedule, you need an application form, just give me a call, shoot me an email. You'll get a same-day response.
All right. Take care, Ernie.
Cheers, Alan. Take care. Bye now.
Bye. All right. So now I'm going to go to the final segment here. And I want to show you where I am with Estate View and also a particular situation. So what I have here is the Estate View software. You can go to estateview.link, L-I-N-K, put in that your email address is test@test.com. Use the super secret passcode test, TEST, and use it for yourself for free until we go commercial with it, which I hope will be by January, possibly before. But here I have Joan More Than This, and Joan is 71 years old and has a residence or residences worth $5,250,000 that are going to grow in value at 3% a year. She has investments of $52 million, and she spends most of her cash flow on appropriate things. She saves about $125,000 a year. Her growth rate on her investments is about 7.5%, minus 0.4% in fees paid to her advisors, and 1.9% of the amount of investments paid in income taxes annually. She lives in Florida, so there's no state income tax, hallelujah. Her parents left her about what is now about $24 million in assets that will never be subject to estate tax. And these assets are also going to grow and be taxed at the same rate. And she has a $20 million death benefit that is costing her about $200,000 a year in premiums that she's paying. She has children, so some of these premiums are based on the $17,000 per child withdrawal powers. But above and beyond that, for her 3 children, she's losing estate tax exemption every year. And if she dies today, then the federal estate tax will be $19,105,000. Now, just to go over some of the inputs here on the left-hand side that brought us to this base, I've got her name, I've got the ability to put in her date of birth, I see that her life expectancy according to the standard IRS tables is 14 years. I'm going to give her 20 years. Most of our clients are going to outlive the IRS tables. Most of our clients don't smoke. Most of our clients are not obese, and wealthy people tend to get better medical care and follow physician instructions. She's used $1,250,000 of her estate tax exemption. And her next question to me is, well, this is nice, but I plan to live 20 years. What happens in 20 years? So I click here, no planning in 20 years. Now, if she was a gardener, I would click no planting within 20 years, but here it's no planning. And you see that in year 20, her houses will be worth $9,500,000. Her investments will be worth $141 million. And I happen to know that it's going to be a lot more than that because she owns stock in a company that pays a healthy dividend yet continues to grow. Her exemption, growing with inflation, will only be $25 million. So her estate tax will be $50 million. But her descendants will not have a bad day. Well, it will be a sad day, but financially not a bad day. They'll inherit $186 million, but they will not enjoy writing the $50 million check. So one thing we can do is we could put one or more of her homes in a qualified personal residence trust. So I go down to here and I say, if I want to do a qualified personal residence trust, what is the 75/20 rate? And how low can I use as a 75/20 rate? And right now the 75/20 rate is about 5%, but the computer also knows that you can use the lower rate of about 4.6. If we went with an 8-year term on the Cupert, then actuarially speaking, she would have an 80% chance of living that long. And the estate tax exemption that we would use to get the house out of her estate would be $2,866,000. So how do I know that? It's because the computer has told me these things, but I can also do a deeper dive on on Cuperts. And just to show you briefly, I can go to the calculator and I can click on Cuperts. And here she's 71, 8-year term, $5,250,000 in houses going into Cuperts. In this case, there would be 2 Cuperts, but they would be pretty much identical. And here you see that her probability of survival is about 78% according to the standard tables. But when I click up and down, it tells me if I go to 10 years, the probability of survival goes down to 70%. So if I want to compare 8 years to 10 years, I can hit duplicate, and then it gives me the same exact scenario, but I can click 8 up to 10. So across the top, I've got Cupert 1 with an 8-year term, and the use of the estate tax exemption is $2,780,000. If I go with a 10-year term, the use of the exemption is $2,286,000. And if she pays rent after the term runs, after a 10-year term, based upon 8% of the value of the home each year, then the estate tax savings, if she lives 15 years, will be $3,500,000. But if she's going to live 20 years, which I said I would have that happen, now you see the estate tax savings is going to be $5 million. So, by the way, I can show every other year in the spreadsheet to make the numbers bigger. And there's other features. I'll just mention one of them, the cutest. It's not working perfectly yet, but listen to this. Thank you, Enid. So this just kind of scrapes the surface of what we can do. Also, while I'm thinking about it, I will go ahead and prepare a PowerPoint presentation showing her how this works. The PowerPoint opens up. I open the PowerPoint and it explains those specific details of CUPERT number 1 and also the spreadsheet information. So just a nice preview of what we're doing here. So now I'm going to go back to the main module, now that I know a little bit more about the CUPERT, in case that's of interest. And then I'm going to go to the installment sale. So what I can do here, and we'll go to the installment sale info here, is I'm going to set up an irrevocable trust for her children and grandchildren. And she might be a discretionary beneficiary of that trust if we put it in an asset protection jurisdiction, if her net worth ever goes down towards 0, which would be improbable. She's going to make a gift to that trust of $2,500,000 in cash or stock. And she's going to sell $25 million worth of a family company or publicly traded stock. And because she's either not a majority member of that family company, or because she puts the stock in an LLC and transfers a 99% non-voting member interest, we are able to have her make that sale for $17,525,000, assuming a 30% valuation discount. Now, if the valuation discount is going to be 25%, then it would be a lower note. But in any event, she's going to get back a $17,525,000 note, bearing interest at 3.75%. Now, where did I get 3.75%? I will click on Look Up AFR, and you see the long-term applicable federal rate this month is 3.99%, but you're allowed to use the lower of this month or the previous 2 months. So I can go to 3.75%. And that is a reason to get these things done in August, because 0.25% of $17 million is actually a little bit of money. Alexa, what is 0.25% of $17 million?
From morningstar.com.au. That is a 17,000% return.
Alexa off. So Alexa doesn't know how to do that today. Normally she would. All right. So now I will go, and by the way, look at this 75/20 rate going up. It went up from 4.2% to 4.6% to 5%. in the last 3 months. So that's a good reason to get these things done, because that is the rate that applies for what we call the hurdle rate for a CUPERT, which I could explain later. All right. So what does that little installment sale do? And by the way, the stock that she's giving away, this 25 million worth of stock, shoots off about 550,000 of dividends each year. So that's going to reduce her cash flow. So I'm going to click on installment sale here, and I'll show you what we have. We've put $27 million indirectly in assets into this trust. It's the $25,035,000 plus the $2,503,000 seed capital gift. We've taken back a note of $17 million. So on day one, this trust might be considered to have a future but present net worth of $10 million out of her estate. Saves $4 million in estate tax. Secondly, after 20 years of growth, we have 81 million. The 27 million has grown to 81 million in 15 years. No longer owes the note because the note matured in year 14. Net value escaping estate tax 81 million, bringing the estate tax down to 13 million. Now look, before this, we had it at 45 million. This little installment sale brings it down to 13 million. And another way to look at this, by the way, is by timeline. So depending on what year she dies, this is how much her estate tax will be, the red ribbon. And it doesn't really change that much based on this scenario. But let me change the scenario a little bit. So I can go to the calculator, and I can go to the self-canceling installment note calculator, and I put in she's 71 years old. She has a 14.7-year life expectancy. So I want to do a 14-year self-canceling installment note. And by the way, if you go past the life expectancy, you get a red warning. Warning, Will Robertson. If you go past 14 years, the IRS thinks that you need to have a large net worth in the trust that you're selling to. That net worth would be 24 million. So let's click back to 14 years for now. And now the interest rate, if we increase the interest to take into account that this note will cancel when she dies within 14 years, the interest rate has to go up from 3.75% to 8.885%. So if she lives the 14 years, it backfires. There's a lot more in her estate. But if she dies in year 14, the estate tax savings are considerable. So if she tells me this looks good, but I want higher annual payments on this note, or if she tells me this looks good, but I don't think I'm going to make it that long, I've got a disease that may take me out, then we're going to consider making part of that note a self-canceling installment note at 8.855%. Now, the other alternative is you gross the principal up by 12 million, so you owe 22 million. So that is the self-canceling installment note aspect of this. Getting back to the main module though, if I go ahead and increase the interest rate to 8.8% approximately, and I go with a self-canceling installment note, 14 years, and she dies in 10 years, so I'll bring her date of death down to 2033. then the estate tax savings is more pronounced. Now, what did I do wrong here? I've got something that I did not enter into correctly in the installment sale part of this. I made it self-canceling. I ballooned it in 14 years. I had her die in 23 years. So, not sure what happened. We'll have to talk to Kevin. That's what beta versions are for. Now, the next thing is she says to me, this is great, thank you very much, but I would like to pay no estate tax. What can I do? And the first thing she could do is marry a jerk and leave everything to the jerk. It's probably not going to be well received. Second thing is you marry somebody and you leave assets in a lifetime income trust for them, and then on their death it goes to your descendants. And if they have a large exemption, that could cut the estate tax. But another idea is charity. So I come down here and I click on charity, and see here the children are going to get 121 million. Uncle Sam gets 13 million. But I click on charity, and now charity gets 32 million and the kids get 110 million. So the kids lose 11 million, but the charity gets 32 million instead of the IRS getting 13 million. That's a pretty good deal for a lot of families. What she could do, and what we often do, is she can say 1/3 of my estate will go to each of my children, but if a child disclaims that, then the part the child disclaimed will go into a family foundation to qualify for the estate tax deduction. So child 1, in this example, with a 13 million estate tax, 13 million divided by 3 is about 3.8 million. Child 1 says, I'll pay my 3.8 million of taxes, give me my 40 million. Child 2 may say the same thing. Child 3 may say, I'll disclaim this to the family foundation. So instead of me getting 1/3 of 121 million, I'll get my 1/3 of 100 million. That's 33 million. And then there will be 11 million in the foundation, which I can manage, which I would rather do than pay 4 million of estate tax. But then there's something even better, and that is the charitable lead annuity trust. So I click on charitable lead annuity trust, and now the 32 million that would have been estate taxable goes to the CLAT, charitable lead annuity trust, and there's no estate tax. And for a period of years, there are payments made by the CLAT to the family foundation. So instead of the foundation getting 32 million, over a period of time, it gets the present value of about 20 million going to charity and about 13 million then going to my descendants in 15 or 20 years. So this is an abbreviated way. So the only things I have here is, do I go charity or CLAT? And I chose CLAT. What's the name of it? The JM Family Foundation. And what percentage is going to charity of the CLAT? And I guessed 60%. Now, where did I get that number? I go to my calculator for charitable lead annuity trust. And what I have here is called a non-grantor testamentary, happens on death, charitable lead annuity trust. Let's say the 75/20 rate is going to be 4.8% when she dies. We don't know what it will be. She will be, let's say, 85 at that time. That doesn't really change the numbers at all. Let's say we go for a 15-year term. So CLAT 1, if I chose that the annual payments will increase by 20% a year, which is very common, and that we are going to leave the 33 million into the CLAT, the annuity amount that goes to charity every year is in this column here. So if I had chosen a flat level fee amount to charity every year, it would be $3 million a year to charity. And assuming a 7% rate of return, what the children would get after year 15 would be about 12 million. But if I go with a increasing 20% a year term payment, then the payment starts at 790. The last payment is 10 million, but there's 18 million left for the descendants. And if I stretch the term to 20 years, then I'm going to have and I'll go ahead and make this fit, show every other line so that it's easier to see. Then the children are going to get 34 million at the end. So the present value of what's gone to charity is 24 million. The present value of the remainder interest to the children is 30 million. So that is about a 40-60 split, 60% to the children, 40% to charity in present value. So that's the first clat that I show, but I can show something even better. So let me go ahead and delete clat 2. I have clat 1 that I just showed you, and I'm going to duplicate it now, clat 2, and I'm going to change so you can see they're almost identical. I'm going to ask Kevin why they're not identical, because they should be identical. But what I'm going to change here is I'm going to leave not $34 million directly. I'm going to leave 99% of an LLC holding 39 million in assets to the clat, and I'm going to take a very conservative 15% discount. So now the clat starts with 34 million, but the calculation is based on 29 million. So the annual payments start at 292,000 instead of 373,000. The present value to charity, 29 million. The present value of the remainder, 24 million. So there you go with your 60-40 split there on that. Now, if she would do this while she's living, then I could show her a grantor clat, and if she did it while she was living, then I would be showing her an income tax savings of $10 million. She puts 34 million in the clat today. She's not going to do that, but this is how the numbers would work. The clat would pay the annuity payment to charity, and then on her death, there would be 34 million going estate tax and gift tax free to 55 million going estate tax free. There would be 10 million of income tax savings. So that helps demonstrate how a clat will work. And I'll go ahead and, just in case you're interested, I will do PowerPoints on clat 1 and clat 2. There are those PowerPoints. We could look at a PowerPoint and see how that worked and what the results are, and we can use that with the client. It does have her name on it, or I can put her name on it if I choose to do so. So going back to the program, that completes what I was going to do for this client. I want to see if there's any questions here that I'd like to review with this. Somehow, Josh, 3 people can no longer hear me, but 2 of them are happy about it. Then how many of us do you think would be able to follow this example clearly? I do not think I would ever have a client of this nature. Well, Glenn, if I win the lottery, I'm going to call you right away. But we can go with much smaller numbers. So let's go with much smaller numbers, and then I'm just going to show you the married couple module so you can see how that will work. So I'm going to reduce the numbers now to well, actually, first though, just for fun, what if she gets married? So here, I'm just going to add a spouse. And the spouse is going to survive her. The spouse will survive until 35 years from now. So she marries a younger person. And now there's no tax on the first death. Everything can be left to the marital deduction trust for the surviving spouse. But then on the second death in 35 years, you're going to have 107 million of estate tax. But if she does the installment sale now, that estate tax goes down from 107 million to 0. That is impressive. I'm going to have to look and see how that happened. That seems too good to be true, but it's because that installment sale thing went longer. I'm going to definitely double check the numbers, but it certainly demonstrates the usefulness. But for your clients, if your clients aren't as substantial, and just to show the married couple, I can now say what the earnings of the other spouse would be after the death of the first dying spouse. I can determine whether, if the first dying spouse does not use their entire estate tax exemption, will there be portability? Will the estate tax exemption drop to half in 2026? These are all the things that we use in determining how to best plan an estate. I can look at the timeline and say, well, what if she lives longer? What if she lives shorter? So all good. Finally, as you know, I can generate a client letter, and I can click there, show introduction, show all these planning techniques that I'm using. I'm not using gifting because she's using all that on the life insurance trust. I am showing an installment sale. I am showing a testamentary charity. I click client letter. The software works on iPads, it works on phones, it works on Apple computers. Eventually will allow you to download it to your computer, but right now it's web-based. But the website drives the program to your computer. Your information does not go to the website. I'm not sure how much we're going to charge for this. It's probably going to be a $500 type of product, but the first year it'll certainly be a lot less expensive than that. So I can open this document now, and I have my explanation letter, which Josh, we can make available for anyone who wants it. The explanation letter will reiterate all of the inputs and all of the assumptions. So that's there. The final thing I want to show you, and this is certainly less than everything you would want to know if you use the software, but a couple things we have here that I think are pretty neat. You can save a screenshot, and then you can also, I want to send this to my client. So the way I send this to my client, I want my client not only to see this, and my client can see this video, but my client may want to change some numbers around for herself or himself. So I click Generate Client URL, and it gives me a password, 5584882. I click Generate URL. I copy this into an email, and I say, Dear John, if you click on this link, it will open my Estate View software. If you use the code number, then you can open it and you can use it and run these exercises and change the various scenarios however you want, and then we'll talk. Remember, please, what we've learned from developing this software over the years and running numbers is you can't just say, I think the wind's blowing that way. I think you should have a clat and a grat and a cupert. Until you run the numbers, you really aren't able to know what's going on. So for those of you who are survivors, you're here. There's a couple of hundred of you from the 700 we started with. Thank you so much for hanging in there with me. And one special surprise, if you happen to be in Clearwater, Florida on December 8th, Will Johns, the nephew of Eric Clapton, George Harrison, and Mick Fleetwood, and a fantastic blues player, is going to be playing for us for a benefit for the Sarah Gassman Foundation. Anything we receive in donations will go to pay for piano lessons for needy children. We've been doing that now for over 10 years. We've taught about 1,500 piano lessons. So if you're interested in meeting somebody who is part of rock history, come out to Clearwater September 8th. Anyway, have a fantastic rest of your day. Thank you to Ken Crotty. Thank you to Ernie Dover. Thank you to Josh, the tech person here. And thank you to every robot, military intelligence, artificial intelligence. This guy's an idiot. Don't listen to a word he says. Okay,